Yep, just did. All right, good morning, everybody, and welcome to Sponsorship Forever, our webinar in which we'll be updating you on the new skilled worker and intra-company transfer routes. I'm Samar Shams. I'm a partner on the Immigration and Global Mobility team at Spencer West, and I'm joined by my colleague, Talita. Do you want to introduce yourself?
Yeah, hi, I'm Talita Degwa, also an associate partner on the immigration team at Spencer West.
So today we're going to talk about sponsorship, and we're very excited to do that. But we also practice a lot of other types of immigration and global mobility work. So all different types of work routes and personal immigration routes. We gave a webinar in November where we talked about the new immigration rules in general, the post-Brexit rules, post-transition period rules. But we're really pleased today to be able to concentrate just on sponsorship because it is quite a complex route, one of the ones that changed the most, and a lot of the changes are super interesting. So we hope you will enjoy it as much as we've enjoyed preparing it for you. Do feel free to ask questions as we go along. If I could ask you to please put your questions in the chat, that would be great. And if we don't get your questions today, just feel free to get in touch after the webinar. Our email addresses will be at the end. So without further ado, I'll summarize what we're going to do today. I am going to speak briefly about European Economic Area nationals because they do now need work authorization if they're coming to the UK now. Then we're going to talk about the main visas for sponsoring people to work in the UK. There are two main types of sponsored worker visas. That's the skilled worker route and the intra-company transfer route. Those are the visas we are going to be concentrating on today. There are other types of sponsored worker visas. So for example, a particular type of visa for graduate trainees. There are particular sponsored visa types for some temporary workers, interns and other temporary workers, temporary creative or sporting workers. But today we're just going to concentrate on the two main types of sponsored worker visas, and those are skilled worker and intra-company transfer worker. We'll talk about the English language and maintenance changes for those routes and also the COVID-19 policies that affect them. So in terms of European Economic Area nationals, we are now in the post-Brexit, post-transition period. And EEA nationals who are coming to the UK now for the first time, moving to the UK, they do need visas. And if they want to work in the UK, they need visas that authorize them to work. Now, if they were living in the UK by the end of the transition period, which was 11 p.m. on the 31st of December, 2020, then they might still be eligible to apply for the EU settlement scheme, the deadline for which is 30th of June this year. If they were working in the UK by 11 p.m. on the 31st of December, 2020, then they might be eligible for a frontier worker permit. And that has the same, if you want to come to the UK to continue working here, but not living here after 30th of June, 2021, then you would need your frontier worker permit to do that. Otherwise, EEA nationals, European Economic Area, and Swiss nationals will be entering the UK as visitors for without having to make a visa application beforehand. So if they just come to the UK and go through the e-passport gates, for example, then they will be entering the UK as visitors. And they can do so using a passport or a national ID card until October of this year, after which point they can only use their passport. They can't use the national ID card to enter. Now, it's important to remember that a lot of business activities are permitted to visitors. So there are a lot of things that European Economic Area nationals can do in the UK without getting a visa beforehand, and just kind of rocking up to the border and entering in and undertaking some business activities. So those include things like having meetings. You could be briefed on a piece of work that you'll be doing. You could negotiate a contract. You can go to conferences. But what you're not allowed to do is work. Okay, you cannot work in the UK as a visitor. And any kind of selling of goods or services to the public counts as work. And so if we revisit some of those activities that I just listed, consider whether you're being paid for them. So yes, you can have a meeting with a client, but if you're then going to be billing for that meeting, then that would probably count as work and would not be allowed under the visitor rules. If you're being briefed on a project, that's fine, but you'd have to do the work outside the UK. You can't do the work inside the UK because otherwise you would be working as a visitor, and that's not permitted. So this brings us to the fact that European Economic Area nationals, as well as all other non-UK nationals coming to the UK for work, will need a visa permitting work. And so we're going to talk about sponsorship, which is the backbone of the work visa regime in the UK. Hi, Wendy. Wendy's just put a question in the chat asking whether the UK will be part of the Schengen scheme. I don't think so. I haven't heard anything on that. Talita, have you heard anything on that?
No, nor have I.
I would be surprised if they did so now, but that would be great. So for those who don't know, the Schengen scheme is a scheme whereby a lot of the EU states allow for people to obtain visas for certain business activities within the whole Schengen area, what's called the Schengen area. But the UK has never been part of the Schengen area, and I don't think that it will do. Thanks for the question, Wendy. All right, so let's talk about what we really want to talk about today, which is sponsorship and the skilled worker route. So first we'll talk about the skilled worker visa, and then we'll talk about the intra-company transfer one. So in terms of the skilled worker route, it's important to remember that it's for employers to be able to recruit people to work in the UK for specific eligible jobs. So it's not a general work visa that you can get and then work in whichever job you'd like. It applies to a very specific employment relationship where the job is defined, the salary is defined, and you're only authorized to work in that role. This skilled worker route replaces what was the Tier 2 general visa, okay? A lot of you might have heard or used the Tier 2 general route. Now it's called skilled worker. And I do say now it's called skilled worker because in fact, the skilled worker route is simply a modification of Tier 2 general in a lot of ways. Now, one very interesting change to the route is that it can now be used by entrepreneurs who are setting up in business in the UK, because under Tier 2 general, there was a limit on the percentage shareholding that a worker could have, that a Tier 2 general migrant could have in the company that was sponsoring them, in the UK entity that was sponsoring them. And now, very quietly, without much fanfare, that rule was removed from the rules, which basically means that now an entrepreneur can set up a company in the UK, okay, incorporate the company, and then have the company apply for a sponsor license to sponsor workers, and then sponsor them, for example, as a CEO or a senior executive in the UK. Now, it's important to remember, you know, I don't want to make this sound too easy. It is an available option, but applying for a sponsor license it means taking on a lot of responsibility, okay? And in particular, one thing that entrepreneurs who might want to use this route might face as a difficulty is getting someone to act as what's called the authorizing officer on the sponsor license. Now, when you apply for a sponsor license, you nominate people in your company to serve, or in your organization to serve various roles, to act in various roles that are required to support the sponsor license, support your sponsor duties, fulfill your responsibilities to the home office that you sign up for as a sponsor. And the authorizing officer is the person who has overall responsibility for all sponsorship activities, right? And so an entrepreneur who wants to use this route to set up in the UK is going to have an authorizing officer to act on the license for them. And the authorizing officer has to be what's called a settled worker. I'll put my hand in front of me so you can see my quotation marks, a settled worker. Okay, so a settled worker could be a British national. They could be somebody with indefinite leave to remain in the UK. They could be somebody with either pre-settled or settled status under the EU settlement scheme. They could be an Irish national, and there are a few other immigration statuses of which where if people have them, they could be authorizing officer. But basically you're looking at British national or somebody with indefinite leave to remain. So if an entrepreneur wants to use the route to come to the UK, they'll have to have somebody in the UK with one of those statuses to act as their authorizing officer, okay? And then in terms of applying for a sponsor license, and this applies equally whether you want to sponsor people under the skilled worker route actually, or the intra-company route, you have to first have in place the HR systems that are going to allow you to fulfill your sponsor duties, okay? Because there are lots of records you need to keep on file. There's lots of reporting you need to do. So if some job details change, and so you need HR systems in place so that if the Home Office comes to visit, when they're deciding whether to give you a sponsor license or not, or after they've given you a sponsor license and they're deciding whether to let you keep it, you can point to this system you have or that system you have and say, this is how we would know to tell you if our sponsored migrant is absent for work for 10 days without permission, for example. Okay. And then in terms of the actual application process, the first thing to do is to gather required documentation. That will depend on the type of organization you are, whether you're a private limited company, public, charity, etc. And then you complete an online application form, you submit that, the authorizing officer makes a declaration that they'll fulfill sponsor duties as part of that application, and then you submit the supporting documents, which is now done by email. So that's the process. Any questions before we move on? We're going to go through the route in quite a bit of detail, but if you have any questions so far, let me know. All right, here we go. Just some eligibility requirements, not relating to the role really. Skilled workers have to demonstrate English language ability. We'll talk about English language in more detail a bit later. They can bring their family members with them. And this route leads to settlement in the UK. So that means that the time you spend in the UK under the skilled worker route can count towards residence requirements for settlement. So generally it would be 5 years of residence in the UK required for settlement. If you spend 5 years in the UK under the skilled worker route, you might be eligible. All right, Talita, take it away.
Thank you. So one of the major changes from the Tier 2 general route to the skilled worker route is that the Home Office have now dropped the skilled level for eligible sponsored roles, which is great because now more businesses, industries are able to sponsor for roles that previously were ineligible for sponsorship. So the skill level has been dropped to regulated qualification framework level 3 or above. And this essentially is a A-level or equivalent qualification. This doesn't mean that the migrant would need to hold that formal qualification. It's just more of the skill level of the job, which is important for what the migrant will be doing. So we've listed on the slide some of the affected industries and roles which are now eligible for sponsorship, which were previously ineligible. So we've got building and construction, manufacturing, engineers, retail, property and housing, tech, business support, mechanics and restaurants. This is not an exhaustive list. There's many more roles that have been added to the skilled occupation list. But we've just listed a few here on the slide to give you kind of an idea of, the type of roles that, businesses can now sponsor, which they previously couldn't. So we are seeing more businesses get in contact with us now, thinking about their long-term recruitment and, whether they are eligible to apply for a sponsor license for the roles that they have in their business.
I'll just answer a question. So we have a question from Lucas. Hi, Lucas. Thanks for your question. Lucas asked, does an authorizing officer need to be an employee or director at the company, part-time or full-time? Very good question. So yes, the authorizing officer needs to be either, well, not necessarily director, but needs to be either an office holder in the company's house sense. So it can be director, but could also be secretary, for example, or another office holding role, or an employee. Now, if they are an office holder, there's no minimum time commitment, okay? If they are an employee, then I believe they do have to be full-time. I hope that answers your question, Lucas. And we'll move on to Talita's next slide.
Thank you. So prior to the new immigration rules coming into force in December, the Home Office commissioned the Migration Advisory Committee, MAC, to have a look at the potential medium skill roles that were going to be added to the skilled occupation list, and to see if they could recommend some of those medium skill roles going into the shortage occupation list. So the MAC did a review of the roles and then sent that back to the Home Office and suggested quite a few medium skill roles as well as some highly skilled roles that they thought should be added to the shortage occupation list. However, when the rules were actually brought into force in December, the Home Office didn't actually implement any of the recommendations that the MAC had suggested. And the main reason for that was that the Home Office said they would want to relook at the recommendations once, the pandemic is over and the economic changes in terms of the climate and how things are moving in terms of roles and jobs start to kind of get back to some kind of normality, to see whether these roles will still need to go into the shortage occupation list or not. The shortage occupation list is essentially a list of occupations in the UK which the UK are short of. So by having these roles added to that list, it makes it easier for sponsors to sponsor in these roles and potentially pay them a lower salary than you would actually need if you're generally sponsoring someone under the skill route. We are going to go into further detail about, the different types of salary thresholds that need to be met. So that would kind of make sense a bit further once we get into those slides about actually what the salary would need to, what the threshold for a salary would need to be on the shortage occupation list.
Yes, that's great. Thanks, Talita. So we have a very interesting question from Emma Bashford. Thank you, Emma. So Emma's asking, looking at the changes to the skill level, they seem similar to the old work permits, pre-points-based system, the old points-based system. tier 2 as a rollback. Okay, so let me, for those who might not totally understand from that what Emma is asking about, let me explain. So before tier 2 general and before the skilled worker route, there was a good old work permit system that some of us have been around long enough to remember. And under the work permit system, you would submit a request to the government to approve a work permit and then they would issue it, rather than the sponsorship system wherein sponsors assign their own work permits, essentially. They're called certificates of sponsorship. Now, under the work permit system, regulated qualifications framework 3-level roles were initially eligible. And then slowly over time, the skill level has risen again and again until we got to the situation where it was only regulated qualifications framework 6 with some exceptions for some shortage occupation roles. And now Emma's asking, so are we rolling back basically to the work permit system? And I guess you could look at it that way. In a sense, we are in that, yes, we're going back to lower or medium skilled roles being eligible again for the current version of what was the work permit system. Interesting question, Emma. Thank you. Talita, do you want to tell us about the main policy changes?
Yeah. So one of the other changes was that the Home Office suspended the annual limit on how many certificate of sponsorships that they will give to a sponsor to assign to a migrant worker. So under the tier 2 general route, they were called restricted certificate of sponsorships. That name has now changed and it's now called a defined certificate of sponsorship. So essentially anyone wanting to make a skilled worker application, the sponsor would need to make a request to the Home Office for a defined certificate of sponsorship so that they can then in turn assign that to the migrant worker. The way that the requests are done now is slightly different as well to how they previously were. So the sponsor can make a request on the system that they've got in place to request these certificates. And once the request is made, a decision is usually given within 24 hours. And then the certificate is available then for the sponsor to assign the certificate to the migrant. It's interesting as well that the Home Office have used the word suspended with the annual limit, which does make us think that maybe in the future, the annual limit could potentially come back. But for now, there's no annual limit. So there's no, restrictions on how many certificates the Home Office will allocate to sponsors. One of the other major exciting changes is that the resident labour market test has been abolished. So sponsors are no longer required to advertise the vacancy with the local labour market force for the specified time that they've previously had to do, and the restrictions about where you can advertise and where you can't. So that's been removed, which is great because it does also speed up the processing times for onboarding a migrant as well. So, you don't have to advertise for the full 28 days on the specific, websites and so forth.
Yeah, I just want to repeat that advertising is no longer required. This is a wonderful change. This is really actually in terms of streamlining the biggest change. And it's very, very welcome because anybody who had to try to comply with the record keeping requirements relating to the resident labor market test before will know there's such a pain. So this is a great, great change. Advertising is not required to sponsor workers anymore.
Yeah. Also, the calling off period has now been abolished as well. So if you've got someone here on tier 2 general or skilled worker route and they leave the UK and their visa expires and so forth, or it's cancelled for whatever reason, they then don't need to wait 12 months in order to then reapply under the worker route, which is great. So it's more flexibility for migrants to switch into maybe a different route or come back as a skilled worker. if they have a job offer. Also, the removal of the salary threshold when migrants are going on to apply for indefinite leave to remain. So under the Tier 2 general system, when a migrant was eligible to apply for indefinite leave to remain, there was a different salary threshold that had to be met at that point. And the most recent one was 38,500. So the salary had to be at that level or above. The Home Office have now removed this, so there's no different salaries that need to be met when you're going for ILR. And instead, it's in most cases, it's either the general salary threshold, which is 25,600, or the going rate on the code that's identified for the role that they're in.
Which is great. Okay, so I'm going to explain going rate a bit more in the next section. And now we're going to talk about skilled worker route, salary requirements and policies in great depth, because this is a lot of what has changed. This is kind of one of the main things that's changed about the route. And you might have heard the government going on and on about the points-based system, the new points-based system. We're so modern, we have a points-based system. I'm afraid that that is a myth. So there's, in fact, there's no such thing as a points-based system. There are points-based visas where you're able to trade points for one characteristic against another to gain an overall number of points that's required for the visa. So it's usually things like level of education, age, work experience. And if you have a shortfall of points in one area, then you can make up for it in another area. Now, what the UK has done in this new immigration system is to shoehorn a points calculation into the salary assessment for one visa route, okay? This is the entirety of the basis of the name points-based system. I'm just going to take a minute to answer Katya's question. Thanks for the question, Katya. Katya asked, does the abolition of the resident labor market test apply also to roles for which advertising started in 2020? So it applies to roles for which you're sponsoring people now, regardless of when the advertising started. So if you want to assign a certificate of sponsorship now, and the person's going to make the visa application now, you don't need to advertise the role. If you did already advertise it in 2020, that's fine. And I would include the documentation of that on file, but it's not required if you're sponsoring them now. All right, let's go back to salary. So this is really the entirety of the points-based system. It's this salary calculation that's part of the skilled worker route, okay? Now you'll often hear people talking about the salary requirement, the minimum salary threshold being dropped to 25,600. In fact, the absolute minimum salary threshold is 20,480 pounds annually. And you can get down to that number depending on some other characteristics. So PhD, whether you have a PhD, whether it's a relevant PhD, is it a STEM subject PhD? If the job is on the shortage occupation list. So again, you know, this is why it's important to follow whether the Home Office is going to add those suggested medium skilled roles to the shortage occupation list, because it will affect this analysis of salary. Is the person a new entrant? Now, new entrant can be anyone under 26 years old. It can be a recent graduate and certain people coming off of switching from other visa types. So taking all of these characteristics into account, an applicant needs to earn 20 points, okay? So let's take a look at how this happens. Now, if you look at the rules, there will be the immigration rules, that is. There's a whole table that purports to cover every possible role that somebody could be performing in the UK. And it will state the job title, it will state the skill level, and then it will state the going rate for the role. Okay, so that's what the Home Office has assessed as the going rate for those roles in the UK. And the table actually includes different percentages of the going rate as well. So what 90% of the going rate is, what 80% of the going rate is, what 70% of the going rate is, that's all included in the tables. So this is what you would be using to assess the points for salary. Okay. Now, as I said, in the rules, there are all these tables, and the way it's set up in the rules is they will say, if you're using option A, so, you know, that might be relying on one characteristic or another, option B, option C, option D, then these are the relevant points. But I think just looking at salary this way gives you a better understanding of the whole calculation. So let's just have gain a general understanding of what we're looking at here. Okay, we've got two tables. Now, if you are calculating the points from salary for a skilled worker migrant, you're going to look at both tables. First, you look at the first table listed there, and you have to satisfy one of the rows in this table, even if you gain 0 points. So you see the top row there, you would gain 0 points. Fine, as long as you satisfy that row or another row in this table. Then you move on to the second table and you see if you can make up for any missing points. So if you didn't get to 20 points in the first table, see if you can make up for it in the second table. All right. Now, before we talk through this in more detail, I'm just going to pick out a few terms here that not everybody might be familiar with. So going rate, we discussed, that's what the Home Office has decided is the salary rate for each job. These are listed in the immigration rules, okay? So that's how you're going to know what the going rate is. They're listed in the rules, okay? And then there's new entrant. Again, that's somebody who's less than 26 years old at the date of application. It could be somebody who's a recent graduate, okay? And a couple of other people would be eligible as new entrants. Then you see further down, there's the job being in the shortage occupation. We've looked at what that means. So hopefully the terms are all understandable to everyone. So let's assess somebody's salary looking at these tables. If you've got a salary, I'm looking at the first row of the first table. If you're offering a salary of at least £20,480 and the salary that you're offering is at least 80% of the going rate for the relevant role, then you satisfy this row and you get 0 points, okay? If you're offering a salary of £20,040 and that salary that you're offering is at least 90% of the going rate for the profession, then the person will gain 10 points. If the salary you're offering is £25,600 and the salary you're offering is at least the going rate for the profession, then you get all of your 20 points right there. So this is why people sometimes refer to 25,600 as the minimum general salary threshold, because if you meet that and you meet the going rate for the profession, which you'll know because you're looking at the list in the immigration rules, then you get all the necessary 20 points just by virtue of that, okay? And then you don't need to go on to the second table, okay? But let's say that your salary that you've offered is at least $20,480, but it's not 90% of the going rate. It's not 100% of the going rate. it's 85% of the going rate. Then you're in this first row, okay? And you get 0 points. So we're gonna have to go to the next table to make up the rest of the points. Aha, maybe the job is in a shortage occupation. Wouldn't that be nice? Then you would get all your 20 points there. You've satisfied one row in the top table and you're gaining all your 20 points from that third row in the second table. So I hope that makes sense, because now we're going to quiz you. Right, this is a case study. So let's say there's a tech company and they'd like to sponsor a software engineer. The going rate for software engineers is £33,300. Okay, we're just giving you that, that's in the rules. The applicant is 30 years old and currently residing and working in India for an unrelated company. Now their proposed salary is £20,800. Okay, so what do we know? We know the name of the role, software engineer. So we were able to look up the going rate, $33,300. The applicant is 30 years old. What's the significance of that? Are they going to be eligible as a new entrant? No. And they're residing in India. They're working for an unrelated company. So that means they're not going to be able to transfer as part of the corporate group. We'll look at that a bit later. So is this role, based on this £28,000 salary, eligible for sponsorship? Well, let's look back at our tables. So the salary is at least £20,480. Is it 80% of the going rate for the profession? Let's see, 33,300 times 0.8, 26,640 is 80% of the going rate. So it is 80% of the going rate. So we'll at least satisfy this. But is it 90% of the going rate? Could we maybe get 10 points for it? I'm going to go back. 33,300 times 0.9, 29,970. So we're not going to get any points because it's not, the salary we're offering is not at least 90% of the going rate. So we've just got 0 points here. So let's look at the second table. Does the person have a PhD in a subject that's relevant to the job? No. And nor do they have a PhD in the STEM subject. Is this job in a shortage occupation role? In fact, it is. Almost all tech roles are shortage occupation roles now, at least the high skilled ones. So we've got 20 points there. And so it is eligible. Now, what is the minimum salary in this scenario? Well, it would be the 33,300. Riddy, fantastic. Yes, it is eligible. Riddy's put in that it is eligible because it satisfies more than 80% of the going rate. So what is the minimum salary in this scenario? Does anybody want to put it in the chat? Now we're getting tough. We've kind of just demonstrated it, but I appreciate it's a bit complex. Anybody? What's the minimum salary to get 20 points in this scenario? So it's 80% of the going rate, isn't it? Oops. Let me go back. It's 80% because then we get the rest of the points from there as we illustrated. So 80% of 33,000, again, 33,300, sorry, is 26,640. That is the minimum salary in this scenario. I hope that makes sense to everybody. Let me know if not. And we could explain how the applicant gains points if the proposed salary is 30,300. How would they gain points if the proposed salary is in fact 33,300? So the going rate. Let's look back at the table. How are they going to gain points if they have the going rate? Thank you, Riddy. That's right. 100% of the going rate will satisfy 20 points, as you can see there in the third row, because it's at least 25,600 and it's at least the going rate. Great. Well, I hope everybody enjoyed that. People do always ask for more case studies. Let's now look at a medium skilled role, which is new to those roles that are eligible for sponsorship. Talita, could I get you to read the case study for me?
Yeah, sure. A body shop would like to sponsor a car paint sprayer, another medium skilled role of which sponsorship would be appropriate for the first time under the new rules. The going rate for the car paint sprayer is 23,000. The applicant is 23 years old. Proposed salary is 23,000. Is the role eligible for sponsorship?
Does anyone want to have a stab at this? Proposed salary is 23,000. It's a 23-year-old, and the going rate is 23,000. Let's look at the tables again. So they're going to be paid 23,000. So that's at least 20,480. And they're being paid the full going rate for the profession. So we fulfill that. Do we fulfill this? No, because we're 40 pounds short of the general threshold. So we're going to get 0 points, but we are going to fulfill this. And then we're going to go down here and get 20 points for being a new entrant because they're 23. Beautiful. Wasted on the youth. So it is eligible for sponsorship. Now, here's an explanation of how they gain the points. Okay. In this scenario, the applicant will satisfy the minimum salary requirement, but earn 0 points for salary. They'll earn 20 points for being a new entrant on the job market based on their age. Therefore, they will fulfill the points requirement. Okay, so if you have understood those calculations, then you are really way above the national average for getting your head around the sponsorship regime. And if you didn't understand those calculations, feel free to get in touch. I'll try to explain it to you another time. We're just going to move on because I'm conscious of the time. What can you include in the salary on the certificate of sponsorship when you're sponsoring a skilled worker? What goes towards those salary thresholds we've been talking about? Well, not everything, okay? It includes guaranteed basic gross pay, but for the skilled worker route, it can't include other pay and benefits. And this is different. You know, previously there were a number of allowances that you could include, and now you cannot, okay? So I've listed there that you can't include overtime or bonus pay, even if it is guaranteed. Previously, you could include some guaranteed pay and benefits like those. You can't include allowances for accommodation or cost of living allowances for the skilled worker route. You can't include any payments that are one-off, so they have to be annual. And you can't include business expenses, so travel back to the country of origin. Now we've got a question from Riddy. To conclude, does it mean that only if 20 points have been earned, the employer can sponsor the employee or migrant? Yes, correct. You need 20 points for the migrant to be eligible for the skilled worker route. So we were just demonstrating different ways of getting to those required 20 points. Okay, let's talk about the other main category of sponsored worker. That's the intra-company transfer. So this route is for transferring employees from linked overseas entities, okay? So when you make a sponsor license application, you can specify that you're linked to a number of other corporate entities or organizations in the same group. And then you can transfer people to the UK under the intra-company transfer route. Now, a lot of businesses we've noticed have now been asking to add the intra-company transfer route, particularly businesses with EU branches, because previously they could use the skilled worker route for everybody from outside the EU. Now they're going to need the intra-company transfer route to transfer people from EU entities to the UK, and they're adding this capacity to their sponsor licenses, which is another thing you can do. If you already have the skilled worker capacity, then it should be free actually to add intra-company transfers. Now, to transfer somebody under the main intra-company transfer route, then they need to have worked for the company, for the organization overseas for at least 12 months before applying. There is an exemption for high earners. So that means people earning £73,900 a year or more. Dependent family members can join. Intra-company transferees are not eligible for settlement. Okay, so the time spent under this route does not count towards the residence requirements for indefinite leave to remain in the UK. And unfortunately, there have been no changes to the minimum salary threshold for intra-company transferees, which is £41,500, nor to the skill level. For intra-company transferees, the required skill level is still Regulation Qualification Framework 6 or graduate level. So why would you use the intra-company transfer route instead of the skilled worker route if the skill level is still higher, if the salary level is higher? It seems like, you know, even if somebody is part of the group, you could just sponsor them under the skilled worker route. Well, there are some advantages still to the intra-company transfer route, not as many as before. So previously, even though you had to advertise for skilled worker jobs and not for intra-company transfer jobs, and now that you don't have to advertise for anything, you know, that's a moot point. But there are still advantages to sponsoring people as intra-company transferees. So whenever you sponsor an employee, you are going to have to justify your sponsorship in some way. And so that's what the defined certificate of sponsorship request process is about. You're saying, you know, we need this person. Maybe you don't have to prove that you can't find someone in the UK resident labor market here through advertising anymore, but you still need to justify why you want that person. Now, with intra-company transferees, that whole justification process is kind of assumed. The justification is assumed. You need them because they are familiar with your corporate group. They have experience in your corporate group. So there are kind of no further questions asked about that. And you do get to take advantage of using undefined certificates of sponsorship for these migrants. So that means that you don't have to request them on a case-by-case basis, as Talita was describing with the defined certificates of sponsorship. You get an annual allocation based on, you know, a business case you've put to the Home Office, and you can use those to sponsor people under the intra-company transfer route. Now, Wendy has asked whether intra-company transferees can now switch to the skilled worker visa. I'm not going to tell you, but Talita will tell you later. You were not dreaming it, Wendy. But just going on with the reasons to use the intra-company transfer route instead of skilled worker. One reason a lot of sponsors use it is that you can basically, when the person is not required in the UK, they can be sent to their country of residence where they're an employee of the linked overseas entity. And in that time that they're overseas working for that other group company, the salary requirements for sponsorship do not apply. So if they're not in the UK, the salary requirements don't apply. So yes, the salary level is still quite high for intercompany transferees, 41,500, but it's only relevant whilst they're in the UK. Whereas for skilled workers, you know, that's not the case. And so not only does that mean that, you know, you are going to have to be paying the skilled workers the salary in the certificate of sponsorship throughout, but also you're going to have to keep records of that. So there is just more of a record keeping burden there than there is for ICTs. Now, depending on your industry, you might or might not be very interested in that. You know, tech companies use that a lot to bench workers back to their country of residence between projects when they're not, you know, working on client projects. So it can make a big difference depending on your industry. Now, another reason to use the intercompany transfer route is that it's more generous in terms of allowances. So it can include allowances as long as they're guaranteed to be paid for the duration of the employment. You can include what the Home Office refers to as a mobility premium for the additional cost of living in the UK, but that still doesn't extend to what it considers business expenses. So, you know, you wouldn't be able to kind of buy a ticket and then expense it and count that amount towards the salary level to meet the salary requirements. But the salary can include an amount paid for accommodation up to 30% of the total salary package. And that doesn't mean that you have to limit providing the accommodation to 30% of the total salary package, but the Home Office will only count up to 30% of the payment for accommodation towards the salary requirements. Now, also, English language is not required for the intercompany transfer route. So intercompany transferees do not have to demonstrate English language ability. Talita?
Yeah, thanks. So just like the skilled worker route, which I mentioned that they had got rid of the cooling off period, the same applies to the ICT route. So if a migrant had left the UK on this route, they then wouldn't need to wait at least 12 months in order to re-enter either on this route or the skilled worker route. There are, however, maximum periods which a migrant can remain on the ICT route, which is essentially no more than 5 years in any 6-year period. However, if the ICT migrant is a high earner, so earning 73,900 or above, then they can remain in the UK for no more than 9 years in a 10-year period. So two slightly different periods, but the general one is no more than 5 years in any 6-year period. So this is, I think someone asked a question about the switching. So you can now switch into and from this category. The major change is that you can actually switch out of this category, which you previously could not have done. So for example, if you've got a migrant here on an ICT route, they could potentially switch into the skilled worker route, providing they meet the requirements of that route, which is great. You know, migrants couldn't previously have done this. However, if a ICT migrant were to switch out of this route to, for example, a skilled worker route, the time that they've spent on the ICT route in the UK would actually count towards settlement. So if they did go into the skilled worker route after being in the UK for at least 5 years, they could then apply for indefinite leave to remain, but the time spent as an ICT migrant wouldn't count towards that period.
Okay, let's talk about English language and maintenance. So a great change in the rules is that you only need to demonstrate English language ability once at the requisite level. So let's say, you know, for these routes, basically the level stays the same. So as long as if you did have to show English language, as long as you did it in your first application, you won't have to demonstrate it going forward. You know, so if you apply for an extension, and if it's the same at the settlement stage, you don't have to demonstrate it, then indeed it is the same level at the settlement stage for these routes. Now, however, the application forms do still ask for the English language test number. I don't know if that's just the Home Office hasn't revised them in line with the new rules, or they still want old test numbers, but just be aware of that. You shouldn't be refused for providing an old test number, because it's not, in the rules, it is not a requirement that you have to demonstrate English language ability again. So just keep that in mind. Don't be scared by the form asking for it. It is unfortunate that it does. You can also rely now on GCSE, A-level, or Scottish Highers to demonstrate English language initially for this route. And a higher education provider can also confirm that they've assessed a degree level course applicant. That's for student routes.
Right. So the maintenance requirement, which is a requirement for both skilled worker and ICT route, the main applicant must have at least £1,270 in their bank account in order to evidence that they meet the maintenance requirements, or alternatively, their proposed sponsor can certify their maintenance, which is essentially ticking a box on the certificate that they intend to assign to the migrant, stating that they will cover their maintenance if needed within the first month. The way that dependents' maintenance requirements need to be evidenced is slightly changed. So the dependent partner would need to have at least £285, first dependent child £315, and then any other dependent child £200. So the slightly changed levels of funds than previously needed to evidence. All funds need to be held for at least 28 days in their bank account, and you can now rely on electronic bank statements. You could have previously relied on them as well, but in addition, you had to submit either a letter from the bank confirming the statements, or having the bank stamp and sign each page. This is no longer required, so they could essentially just print off an electronic bank statement on the bank statutory paper and provide that to meet the maintenance requirements. One of the other great changes for the meeting the maintenance requirements is that if you've got a migrant worker in the UK, for example, and they've been in the UK for at least 12 months or more and have previously met the maintenance requirements on the current route which they're on, then they do not need to then evidence meeting the maintenance requirements again. So this is great because under the Tier 2 general route, no matter what application you are making, say, for example, an extension as a skilled worker, you would still then need to show how you were meeting the maintenance requirements. So if they meet the requirement that they've lived in the UK for at least 12 years and have also met the maintenance requirements previously, then they wouldn't need to meet this requirement again.
All right, let's talk about COVID-19 policies. And then we'll take more questions if anybody has general questions they didn't get a chance to ask earlier.
Yeah, so the COVID-19 policy, there's various concessions currently in place which affect people that are either in the UK or abroad. And there's obviously various situations where people are stuck abroad or currently in the UK and can't leave. So the Home Office has put out a number of concessions to kind of try and cover as many migrants and visa holders as they can. We've listed a few on this slide and the next slide, which we feel that are more applicable to the routes that we've obviously discussed. We do have an article on our website under the News and Insights tab, which is immigration and coronavirus, which goes into further details about the full concessions that are available to visa holders. So do feel free to take a look at that as well. So the first one we've got is sponsors are no longer required to report change of location if the sponsored migrant is working from home. So like the majority of us in the UK, we're all working from home where we can. So the Home Office have relaxed the requirement for having to report where a migrant worker is actually physically working from. So if you've got a migrant worker that's working from home, this doesn't have to be reported on the system. The next one is sponsors can continue sponsoring skilled workers who are absent from work without pay for 4 weeks or longer. So previously, before the pandemic, if you were sponsoring someone who was absent from work without pay for 4 weeks or longer, you essentially would have needed to stop sponsorship. However, the concession allows for this to take in consideration that people are needing to self-isolate, for example, or take time off, if they've got the virus or they're ill, for example. So this means that you wouldn't need to then, stop sponsorship if they are obviously taking time off to self-isolate or to recover from an illness. The next one is these skilled workers can benefit from using the government coronavirus job retention scheme. So if a employer wishes to reduce a migrant's salary, they can do so. It has to be either 80% of their normal salary or 2,500, whichever is lower. And it should be part of a company-wide policy. So all employees should be treated the same. And obviously, if any migrant salaries are reduced, then once these measures have ended, the salaries of the migrants should go back to at least the normal levels that they were prior to the pandemic. The other concession is that sponsors can, for the time being, conduct right to work checks via video conference. So people are allowed to obviously come onto the video conference, show their passport and a visa to the specified person within the company, who can then obviously take a note of that. However, once this concession does end, the sponsor would then need to do another right to work check to see the documents physically in their presence, and then obviously keep documentation of that. So they haven't actually said when this concession will end, but it's just worth, just keeping up to date with what's going on with the right to work checks, because they will need to be redone again if they have been done initially by video conference.
Yeah, that's right. And there is also an article on our website that we've posted about how to conduct the right to work checks via video conference. If you want to make sure not to miss the Home Office announcement when the right to work checks via video conference allowances are terminated, then I would encourage you to sign up to our monthly newsletter if you don't already receive it, because we'll definitely put it in there. Now, before moving on, we are going to talk about some other COVID-19 concessions, but Riddhi has asked a question about the second concession, about sponsors being able to continue to sponsor skilled workers who are absent from work without pay for 4 weeks or longer. So Riddhi has asked whether this is allowed in relation to a migrant worker working from their home country, even if it's a month or two. Riddhi asks, does the Home Office have to be informed, even if it's within the scope of their visa or not impacting it? Actually, it is about the first concession.
Working from
Yeah,
home.
you're right. Because I was like, if they're working, then they're not absent from work. So sorry. Riddhi's question relates to the first concession about the change in job location. So he's asking if the job location changes such that the person is working remotely from their country of origin, does it have to be reported? So I did actually advise a client on this point, and I corresponded with the Home Office in order to do so. And we decided best practice is to report it if they are going to be working remotely from overseas. And also I would just caution that there are two things you have to keep in mind in that situation. If it is a skilled worker, to which your question relates. First of all, that there are limits on the absences from the UK that are permitted in order to be eligible for settlement. So just make sure that extended absences don't fall foul of the limits on absences for indefinite leave to remain if they want to apply for indefinite leave to remain. And then the other thing to consider from an immigration standpoint is, again, if they're a skilled worker, you have to be maintaining their salary as stated on the certificate of sponsorship in that time, even if they're not in the UK. And then finally, one isn't actually an immigration point, it's more of an employment law point. So I'm going to say one thing about it and nothing more, because this is the extent of my knowledge on this point. They might be gaining employment rights in this other country where they're working. There might also be tax considerations. So Talita and I can't advise on that because we're humble immigration lawyers, but we can refer you to colleagues who advise on employment and tax matters to tell you about that. So I hope that answered your question. Great, thanks, Riddhi. I'm glad it was clear. We'll talk about a few more COVID-19 concessions.
Yeah, so another one is if an applicant is in the UK and wants to make an application to switch into another route, they can now do so without returning to the home country where they would have usually needed to do that first. And currently they don't need to show that the application is urgent for making it in country rather than returning back home to make such an application. Another concession is visa holders who have a visa expiring between the 1st of January 2021 and 28th of February 2021 who are unable to leave the UK due to COVID-19 restrictions. They can now request additional time to remain in the UK, which is known as exceptional assurance. And this is essentially by making a request to the Home Office prior to the visa holders' visa expiring and setting out the reasons that they can't leave the UK, and then waiting for the Home Office to give a decision on whether they'll be given further time to remain in the UK after their visa expires. And then finally, the absences requirement when a migrant is going on to apply for indefinite leave to remain. So Samar just touched on that slightly. So if a skilled worker has been in the UK, for example, for at least 5 years, then they can, if they want, go on to apply for indefinite leave to remain. One of the requirements when making the application is that the applicant needs to evidence that they haven't been out the UK for no more than 180 days in any 12-month period. There are some exceptions to the absences, and one of the exceptions that have now been added are absences due to the global pandemic. So what the Home Office have said is if you've had absences due to the global pandemic, for example, travel restrictions or having to self-isolate and not being able to come back, and you've obviously spent more time at the UK than you would have initially wanted to, any of those absences will not count towards the 180-day calculation, which is great for obviously people that have been stuck abroad and have been worried about whether they will be eligible to apply for indefinite leave to remain and whether their absences would potentially affect that application, which now they won't, because if it's due to the pandemic, they won't be counted towards the 180-day rule.
So just to fold that back into Riddhi's question, I just want to distinguish between, someone working remotely from their home country because they've elected to do so, versus somebody who went there and then got stuck. So this last concession relates to people who, they're being prevented from returning to the UK has to do with the pandemic, and they'll have to provide evidence of that. When they apply for indefinite leave to remain, which they should gather now, because it's going to be a lot easier to gather now than maybe in 3 years' time or whenever they're eligible for indefinite leave to remain. So I just didn't want us to conflate those two situations. I hope that's clear, but let me know if not. Okay, so thank you very much. We really enjoyed that. I think we gone a little bit over an hour, but we'd be very pleased to stick around and answer any questions that you didn't have a chance to ask yet. So feel free to put those in the chat. And otherwise, I would just wish you a very good day, and I hope everybody stays safe. Really appreciate everybody coming. I know everybody's got kind of Zoom fatigue and webinar fatigue, but you know, we do put a fair amount of effort into these. I hope they're useful, and it's always great to just have contact with people in any case. So thank you very much. So we don't have any questions, and we'll be ending the session now. It's our pleasure. Thank you, everybody.